You're listening to the Immigration Lawyers Toolbox podcast, the podcast that keeps your practice sharp and your clients happy. I'm your host, immigration lawyer John Khosravi, and every week we're bringing you insights, tips, and real-world conversations with top immigration attorneys and industry leaders. Whether you're here to grow your practice, stay on top of the latest trends, or get inspired, you're in the right place. Ready? Let's go. Hello, fellow Toolboxers. Welcome to episode number 405. This is kind of like an emergency episode I wanted to put out. I've been talking about it for a while, the issues that we're going to talk about. Interview with Sameer Khedekar about NTAs being sent to cases you wouldn't typically think about, people with extensions of tourist visas, H-1B change of status, and you probably know already people with adjustment pending to out of status, getting NTAs or even being detained. But his focus, Sameer, because he does a lot of H-1B work, he's in Silicon Valley up Northern California. He's been seeing more and more of this and dealing with it. So we go into depth of what the situation is and how you handle it and all that kind of stuff. So I wanted to jump in and get this one as soon as possible so you could hear it and are aware of this nasty situation that's happening. This is kind of information I'd like to provide. If you want to join our community and you're a lawyer, a U.S. lawyer, email me at info@immigrationlawyerstoolbox.com. Join our community page. I'll circle out as so taking it off Facebook so we get out private discussions and more a curated space to become better immigration practitioners. Again, just email me at info@immigrationlawyerstoolbox.com. We have a bunch of courses there as well. You'll see when you get there. Having said all that, none of the information provided here is intended as individual legal guidance. Please consult with an attorney about your case, but you all know that already. Let's get it started. Hi, Sameer. Thank you for coming on the show again.
My pleasure, John. Good to be here.
Awesome. So let's kind of get into it. We've been on the show before, so I have a link to your background. You've been practicing for many years and on various degrees of big firms, small firms. Yeah, you have a great background. But on LinkedIn, you recently been posting, and I've been talking about it every week on my show and linking to it like, oh my God, these period of authorized stay NTAs are coming. You're at the forefront of it. So could you share how it started coming on your radar and the newest developments that you've seen?
Yeah, I mean, they're definitely period of authorized stay NTAs, but in many cases, they're not too. They're NTAs on people who filed transfers within their grace period, H-1B transfers within their grace period. So we're focusing mostly on the H-1B related NTAs that have been coming down the way, mostly because those are who our clients are, and that's like the community we're in, right? And in most cases of all the NTAs we've seen a lot. Most of them are results of people who've either left their H-1B job or were laid off, right? And when the company withdrew the H-1B, it triggered an NTA. And the NTAs, when we get them, make no allusion to any other steps the individual may have taken either before they were laid off or during the grace period to mitigate their status or the period of authorized stay. They just said, H-1B withdrawn, you have no status, go to immigration court.
Wow, and even nastier, I'm seeing those people filing for extensions of B2 tourist visas getting NTAs. That's like,
Yeah.
I don't even know what to say about that. That's a kind of a tremendous disturbance.
Well, remember, like in March or April, they archived that page on the USCIS site, which alluded to the B1, B2, option as like a legitimate option for those that have been laid off from their H-1B
Yeah.
jobs. So that was probably a foreboding. We do have a client who is in that position. They had a pending B1, B2. Then they were lucky enough to find an employer who got them back into H-1B status again. And so we're about to file a motion to terminate their immigration court case because the employer successfully was able to change it from pending B1, B2 to H-1B. And that just happened a couple days ago.
Have you been going to court yourself? Because I remember you talked about two cases that came different judges, got different kind of results. Can you talk about that case? And are you taking this? Or are you referring out? Because a lot of people do this side of the immigration aisle. They'll do removal hearings and don't know what to do about that. How are you handling that?
It is pretty odd, right? I think those that do removal almost never do H-1Bs and vice versa, or just kind of do business immigration and vice versa. I've been to immigration court before in my career. I wouldn't say that I'm an expert, and I certainly know nothing about the removal side of things. Okay. But it's interesting that these cases, while they are in immigration court, they relate to H-1B related or business immigration related issues. So like the motions you file and the arguments you file, you have to have knowledge of that area of immigration law, right? So you need to understand the procedure of immigration court, but the substantive law of business immigration law. And what we're finding is that a lot of the immigration judges and even the ICE counsel, they have no understanding of business immigration law. So we're getting interesting kind of reactions and varied reactions from them. Yes, I am going to immigration court to answer your question. And the reason I do is because I feel comfortable with the procedure. I've done it enough where I understand the procedure. And of course, I understand the business immigration law aspects. And so right now, for the most part, if the courts allow, I'm appearing virtually at master calendars across the country.
And, are they, because from what I know is, like, getting a hearing takes forever. Do they kind of speed it up when you do a motion in this particular scenario? Are you getting them, uh, joint motions and stuff like
Mhm.
that in?
Depends on the NTA and depends on the court. In some cases, the hearings are actually scheduled a few weeks after the NTA has been received. We're rushing to file motions to terminate, and in those cases, the motions have essentially been discussed and litigated within the master calendar hearing.
Oh, wow.
Others have set master calendar hearings out for 2026 or 2027, depending on the court. And so we're filing motions to terminate, and essentially, we're not going into a hearing to argue them. They're just going to be back and forth motions between
Yeah.
us and the government counsel and a written order by the judge.
It's so weird because if someone is, like, on gets the H-1B transfer essentially approved, but they're in removal, could they start working, or how does do you have it you know how to advise on that?
So yeah, it's kind of weird, right? So somebody with an H-1B transfer approved is in H-1B status
That's
and
true,
and
US citizen, they did it.
simultaneously in removal proceedings, right? So it's really odd, but our view is they're in status and they should not be in proceedings, which hence the motion to terminate because they are in status, and if they are in status, the judge will agree. I think it's prima facie evidence that they are not removable.
Now, how do you advise, employers who are gonna be letting people go? I mean, if it's a friendly layoff, then maybe it's thing, but if it's like a firing too, it puts the beneficiary in a really difficult position, paranoid position.
Yeah, it's definitely a kind of a hot topic amongst employers. I am well. We have our own employment-based clients, and we've kind of advised them on what we think is the best practice, which is to wait 60 days to withdraw the H-1B. We happen to have a very kind of Silicon Valley based kind of clientele that's employee friendly and wants to do that. That is not the case with every employer in the country, right? And so um, our view is that, first of all, employers do have the obligation, as we all know, to withdraw H-1Bs. The regulations say immediately upon the termination of the employment. Else they'll be subject to possible back wage claims by the employee, right? So that the employers have to think about that. Uh, we're letting them know. We're letting them, like, when you withdraw a case, it's triggering NTAs, and not in all cases, but in many cases. And I think it's perfectly reasonable to wait a 60-day period, to withdraw the H-1B. Maybe you can enter into an agreement with the employee that you'll wait 60 days if they, if they're able to waive any back wage claims, and that's obviously a topic of kind of state employment law that I'm not, like, conversant in, but yeah, yeah, but these are the crazy discussions we're having. I would say there are some companies that are withdrawing L1s, and we had a client like that. A big company had a layoff, and they had employees in L status, and the law firm withdrew the L1s, which had been their practice up until now, as a just matter of diligence on their part, and that is not required anywhere in the regulations or in the act, and so I would encourage companies not to withdraw L1s anymore because those are also triggering NTAs, and that's kind of unnecessary at this point.
Has there been any consistency you've seen with the NTA triggers, or is it pretty random?
Mostly due to the H-1B withdrawals, I would say, but we've seen different kinds of NTAs. So in one case, we had somebody who's I think may have just been an LPR or a U.S. citizen. Their mother was coming on a B2, and she stayed the full 6 months, and before her 6 months was up, applied for an extension for 3 months because wanted to be with the grandchildren a little longer. Well, the USCIS, whatever technology they're using, picked up the expiration, saw that she had not left, didn't see that she'd filed an extension, and issued an NTA for the mom. Okay, which was pretty crazy. We've seen cases where an H-1B was changing to O-1 uh, just before their expiration. Okay, and the spouse alongside changing from H4 to O3. The H1B was approved, but the H4, the I-539, was rejected because of the wrong filing fees. This wasn't our client, but they came to us kind of telling us what happened. And it was rejected. And so they didn't get the rejection until after the H4 expired. Okay.
A nightmare, yeah.
And it immediately triggered an NTA. And so there maybe there's something
Historically, you
about the
do a nunc-pro-tunc
rejection.
filing,
Yeah.
they would just hook it up, yeah.
So they did a nunc-pro-tunc, but now you can't premium process that, right? And meanwhile, they're in immigration court. So what do you do? Like the nunc-pro-tunc could take several months, and in this administration, there's no guarantee that'll work anymore.
This is happening not only in the kind of business and IV context. IV people adjusting are having this. The craziest scenario I saw a post on Facebook was someone with a K1 fiance visa, married within 90 days, filed I-45 after 90 days, and they got NTA'd. And that might be a good case for a lawsuit that goes to federal court because they designed a system where you automatically will overstay your 90-day K1. So if the
Right.
Congress's intent was to create a system like that, maybe that means the period of authorized stay, essentially with a case pending, is status because, or like it's something it's deferred action, if you will, at least because inevitably every K1 fiance holder is subject to this automatically because of the bureaucracy taking too long to adjust status. So that might be
Yeah, I
like
don't
a
do a
good
lot of
factor to sue on.
that would be a good argument. I don't do a lot of K1s, but that seems like the best argument in favor of the AOS pending as a period of authorized stay that should be viewed as status. But I do have clients. Do have a client who was on an AOS, is on an AOS pending based on AC21, I-45 pending for 5 years now, based on an approved I-140, right? Same or similar job, and got a new job, changed her jobs, did not do an H-1B transfer, just chose to move over on the EAD, and then got hit with an NTA. And so now we're like, she's been here for 15 years, right? Husband's working at a great company, like their life is here. She didn't think anything of it at the time, right? Neither did any of us. Like, I mean, we generally say try to keep your underlying status going,
But
but
it's
we never ever
yeah.
knew like the penalty for not doing so would land you in immigration court, right?
Mm-hmm.
And so had we known, that would have totally changed the 20 odd years of kind of advice that I've been giving. So,
I mean, it was a standard practice. Like, only reason I would say for marriage
yeah,
case, for example, is like if marriage falls apart, at least you have the underlying status. Never would I imagine that would
yeah,
NTA. That would be the thing. Like we have one case where a person on H1B and they're like, well, when we get the EAD, it's a marriage U.S. citizen. I'm going to change jobs and stuff like that. I'm like, no, don't do that. Stay at the same employer even. Don't rock the boat at all.
yeah.
Just wait for the case to finish. And so that's the advice you got to give because it's unnecessary and frankly cruel a lot of times for a B2 extension. Just give an RFE or deny it and then do something. But to just not pay enough attention that they had a case pending to the NTA is just insane. Waste of core
Well, then
resources
what you're
too.
getting now, poor resources, and what you're getting is an irregular application of formerly consistent areas of law, right? So if you had an H-1B and you change jobs and you have an H-1B transfer, everyone knows you can start working upon the filing of the transfer.
Yeah.
The I-9 rules say so. The regulations say so. You're pretty much in status, right? But
Yeah.
now put that person in immigration court before an immigration judge that doesn't understand what's happening here, likes to defer to government counsel because they have a backlog of 20,000 cases, and suddenly you get disparate results kind of in the same place, which is what happened to us. We had two cases in Dallas. One considered the pending H-1B transfer to be in status. The other person said, that doesn't help me until I see the approval. Right. And so, and notwithstanding the fact that the person's like working, for that new employer. So
Yeah.
it's pretty crazy. Yeah.
I mean, when you see the J1 2-year home residency requirements being denied by DOS as a matter of policy, then like it's the hands of the administration really
Yeah.
push their hands on the scale. But it's a wild scenario. I wanted to share that information with because it's going to affect a whole chunk of people. I would never even thought this stuff was possible.
Yeah. This is pretty crazy times.
Well, Samir, thanks so much for coming on the show. I'll put your LinkedIn page in the bio so people can access it. But if people want to reach out to you, what's the best way for them to do that?
Yeah. Feel free to my emails on our website, Sameer at vanguardvisalaw.com. Happy to kind of help anybody who needs any advice here. I am trying to post as much as I can on LinkedIn. That seems to be the most kind of effective way to kind of spread
Yeah.
these kind of very recent real-time developments that are happening with NTAs in the world of business immigration now, which we've never had to deal with before. So I'm trying to put as much information out there as possible as we get
Yeah, whenever I see a post, I'm ready. I'm always ready for my jaw to drop. Like, oh no, what kind of? It's gonna tell us now. What's happened now?
it. Uh-oh.
So
I
stay
don't
on
know
the line
whether
for
to
a
laugh
couple.
or cry. Yeah.
Yeah,
It's like
immigration law is just every day is something different.
yeah,
I mean, it's interesting area to say the least. The practice, but you always got to be on your toes and ready to pivot and do all sorts of stuff you didn't expect you need to do.
exactly.
Well, thanks again for coming on. Stay on for a couple more minutes
Yeah,
after the show, but yeah, thank
sweet.
you.
Thanks for having me, John.
If you like this episode, follow us on Instagram. Our handle is Immigration Lawyers Toolbox, where we post the latest statistics, tips, and more. And stay tuned for more from the Immigration Lawyers Toolbox podcast.